So over the previous couple of lectures, I've been talking about unincorporated associations, and today I'm going to be talking about how the funds of an unincorporated association are applied. So application during the association's existence. The basic principle stipulates that association funds are to be applied in accordance with the terms on which they are held. So we've got the contract holding theory, money is applied in accordance with the association rules. So under the contract holding theory, money is applied in accordance with the rules of the association. Now recall that under this theory that a transfer is a transfer to the association's members subject to the contract which exists between them, i.e. subject to the association's rules. So the money must be applied in accordance with the association's rules, which will specify the various purposes for which the money can be spent. Note, however, as mentioned before, the association's rules can be changed by its members so as to allow the funds to be spent on new purposes. So the common law rule is that the association's members can only change the rules if acting unanimously, but this could be varied by the rules themselves. For example, the rules themselves could simply provide for majority consent. And we've also got charitable Denley trusts, so money applied to charitable, non-charitable purposes. So under charitable or Denley trusts, money is applied to the relevant charitable or non-charitable purposes at the date of the transfer. Okay, so they are therefore unchangeable. So that is how funds are applied during the association's existence, but of course it is possible that an association will cease to exist and come to an end. In other words, it will dissolve. So we must now determine when an association comes to an end and what will happen when that occurs. So when does dissolution occur? An unincorporated association can be or is dissolved in the following ways. Firstly, in accordance with the association's rules. So the rules might specify, for example, that the association will be dissolved if 2/3 of its members agree to a dissolution. If there is no provision as to dissolution in the rules, then the members can dissolve by unanimous agreement under the common law. So this is the first way in which the association may come to an end. The second way is when the number of members falls below 2. So recall a couple of videos back where we defined what an unincorporated association is. The case of Burrell holds that an unincorporated association comprises of 2 or more persons who are bound together for mutual purposes under contract. So it follows then that if the membership of an unincorporated association falls to one single person because, of death or resignation as an example, the association will automatically dissolve. This of course makes common sense. One cannot associate with oneself. So that is the second way in which an association will dissolve. And thirdly, when the association has become moribund. Okay, so the third way in which an unincorporated association dissolves if it has become moribund. In other words, it is in a dying state or nearing death. So under the final heading, an association will dissolve when it ceases to function. It might cease to function due to some external event, for example, an allotment association when the allotments have been purchased by the government, or maybe due to inactivity. So as McGarry tells us in the case of GKN bolts, only when this inactivity demonstrates that all concerned regard the society as ceasing to have any purpose or function will it be held that the association has become moribund. In this case, there was a social club which had gradually ceased to operate, and the court concluded that everyone regarded the society as stopped having any purpose or function. And this was evidenced by the fact that membership cards were no longer issued and were looking to sell its final asset linked to the society, its sports field. So the court concluded that all concerned regarded the society as no longer existing. So the club had become moribund and was therefore dissolved. So, application on dissolution. When an unincorporated association is dissolved, it may have surplus funds, and the question is, what happens to the funds that remain when an unincorporated association dissolves? Now, the basic principle applies equally on dissolution. Surplus funds are dealt with in accordance with the terms on which they were held pre-dissolution. So the basic principle, which says how funds are applied during the unincorporated association's existence, as we saw a couple of slides ago, is equally relevant on dissolution. So the basic principle dictates that surplus funds on dissolution are dealt with in accordance with the terms on which they were held before the dissolution happened. So the contract holding on dissolution. So what happens to funds held on contract holding theory pre-dissolution when the association dissolves? So there might be £10,000 worth of assets under the contract holding theory. So where do these funds go once the association collapses? Now, the standard position is that surplus funds are applied in accordance with the association's contractual rules. So it might be then that the association's rules dictate how the money should be divided on a dissolution. If the rules contain an express term determining how surplus is to be divided on dissolution, this term is binding on the association's members. So if there is an express term in the contractual rules saying how surplus funds are to be divided on dissolution, this term is binding. So in such a case, the surplus will be divided in the way specified. Absent an express term, the law implies a term, ordinarily for equal division between members at dissolution. So it may be, however, that the society has dissolved, but there is no express term in the contract that establishes how these surplus funds are to be divided. So in the absence of the express term, the law will imply a term into the association's contractual rules dictating how the surplus funds will be divided. And the term that is implied is ordinarily for equal division between the members at the time of the dissolution. But compare this with the case of Re St. John's Sick and Funeral Society. Okay, the word ordinarily was used because occasionally the term implied will not be one for equal division. So in this case, an unincorporated association existed to provide sickness and death benefits to its members. The membership of the society comprised both adults and children. The children paid their subscriptions to the society at half the adult rate and received the benefits at half the rate too. Given that, when the society dissolved, the court had to determine how surplus funds under the contract holding theory were to be applied. Now, there was no express term, so the court implied a term directing that all adult members be given an equal amount of surplus, but each child was to receive only half the amount of each adult, reflecting the fact that each child paid a reduced subscription rate and only received half the benefits offered. Okay, so dissolution when the number of members falls below 2. When the number of association members falls below 2, the association's contract is discharged. So the approach is slightly different though when dissolution occurs when the number of association's members falls below 2. So under the standard position, as we just looked at, there is a presupposition that the association's dissolution does not bring its contractual rules to an end. So it is for that reason then that any express terms in the contract will govern how funds are to be directed in the event of a dissolution. It is clear though that this presupposition is not appropriate when dissolution has occurred because the number of members has fallen below 2. In this case then, the association's contract must terminate for the simple reason that it's impossible for a contract to exist if there is only one party to it. So in this case then, the fate of any surplus assets must be determined without reference to the association's contractual rules. Any surplus then rests where the contract holding theory's underlying principles leave it. Okay, so as a matter of logic then, the surplus must rest where the contract holding theory's underlying principles leave it. I shall explain. Recall that under the contract holding theory, funds are owned by the association's members subject to the contract that exists between them. When the contract is discharged because the number of members falls to 1, all that is left is the members' underlying ownership. So logically then, the surplus must belong entirely to the last surviving member. The principle plays out in this case of Hanchett Stamford, an Attorney General from 2008. This case concerns an unincorporated association called the Performing and Captive Animals Defence League, and this unincorporated association was formed in 1941 with the aim of changing the law to ban performing animals. So eventually its membership fell to just 2 members, and then the penultimate member died. So the question arose as to what should be done with the £2.5 million worth of assets that the society held under the contract holding theory. Now, the court reasoned that as the association's contract was discharged on the penultimate member's death, the funds simply belonged to the association's members at the time of the dissolution, free from contractual restrictions. And of course, only one member existed, so she, Mrs. Hanchett Stamford, could take the £2.5 million of assets absolutely. So, purpose trust on dissolution. So what happens on dissolution with respect to property held on a purpose trust prior to dissolution? In other words, what happens to surplus funds when those funds were held in accordance with a purpose trust? Now, the basic principle is that the surplus funds are applied in accordance with the law of trusts. So, on the association's dissolution, any trust for its purposes will fail. Charitable trust funds will automatically be applied to stipulates. So, if the trust for the association's purposes is a charitable trust, the funds will automatically be applied to stipulates. And if you don't understand stipulates, I do have a video on the stipulates doctrine. And then the Denley trust. Funds revert to the transferor on a resulting trust. So on the other hand, if the trust for the association's purposes is a Denley trust, any surplus funds will revert to the transferor on a resulting trust. So any surplus money will be transferred back to the person who originally transferred property in the first place. In other words, the person who originally set up the Denley trust. Disclaiming the beneficial interest. So in principle, the beneficial interest under the resulting trust which arises on failure of a Denley trust can be disclaimed, leaving the property which reverts ownerless. So there is one final complexity, the possibility of disclaiming the beneficial interest under the resulting trust which arises on the failure of a Denley trust. So if the beneficial interest under the resulting trust arising from a failure of a Denley trust is disclaimed, in other words, refused to be acknowledged, then the property which reverts is ownerless. Money which is ownerless ultimately goes to the Crown. Okay, so if the resulting trust is disclaimed, the surplus funds don't go back to the transferor, but instead go to the Crown. A transferor disclaims their beneficial interest if they intend that their money not be returned in any circumstance. So a transferor will be held to have disclaimed their beneficial interest under a resulting trust if, when giving their property or money to the association, that they intend their money not to be returned to them in any circumstance. This money will therefore be directed to the Crown. And a disclaimer was seen in the case of West Sussex Constabulary Trust from 1971. In this case, it was said that money given by way of donation to collection boxes, gifts and legacies was held on a Denley purpose trust. When the unincorporated association dissolved, there were surplus funds which in principle would revert back to them on a resulting trust. But the court held that those donors who had put their money into collection boxes had disclaimed their beneficial interest under the resulting trust which arose on the dissolution of the association. They were considered to have parted with their money completely with no intention it would ever be returned. So surplus funds were directed to the Crown instead. So yeah, that's about it. If you have any questions at all about this video, then as per usual, please leave your questions below and I'll get straight back to you. If you enjoyed the video, then make sure you give it a thumbs up and please subscribe to my channel. Thank you very much for watching.